Welcome, everyone. We have a special program here at Berkeley Law today about the Unified Patent Court. 3 years back, Berkeley and Robbins Kaplan and Steve Carlson here, which I'll introduce formally here in a moment, really got to looking at the UPC and what that would mean for the future of patent litigation, patent enforcement, innovation here in the United States. Steve was kind of a luminary in this idea. He brought this to me, and when he first brought it, I was thinking that's a problem and that's an issue that's not really going to affect many U.S. companies. Steve corrected me, told me I was wrong. It's not going to affect companies today, but it's going to affect companies in the future. Turns out, much as I hate to say it, I was wrong. He was right. And now that I've said it on a recording, I'm kind of bound by that. But this has been a partnership with Steve to really bring this knowledge to U.S. companies and to U.S. policymakers. And so I kind of wanted to start this with a thank you to Steve for highlighting this issue before anybody else was. So with that, let me introduce kind of the co-founder of this entire UPC program, and that is Steve Carlson. He's a partner at Robbins Kaplan, a well-known and well-respected U.S. patent litigator, but a U.S. patent litigator with a lot of clients that do business worldwide. And I think that's what brings this kind of special knowledge. So, Steve, I want to let you introduce your co-panelist, who I will also mention has been with us since day one of all of this, and really been a thought leader for us here at Berkeley Law. So thank you, and all yours.
Thank you very much. I'd love to introduce my co-panelists here, Konstantin Schallmoser from the firm of Bonnabry. I've been working with Konstantin and his colleagues now for really 20 years, since I've been a junior attorney here in Silicon Valley, practicing now for over 20 years in patent litigation. I've been aware of the German system and the importance that it's had, kind of the power it's had in patent litigation. What's happened in the last 20 years is there's been a tightening of the U.S. system, making it really hard to enforce patents in the U.S. Meanwhile, we've had this launch of the Unified Patent Court in Europe, and that very quickly has become probably the foremost forum in the world for enforcing patents. It is cheaper, faster, and more reliable in terms of what you may get as a claimant. And so what we did starting about 2010, I worked with Konstantin's colleague, Alexander Harguth, and then Konstantin in doing these books about the German patent litigation system to explain it to the American audience. It is a different system out there, in many aspects quite advantageous from the plaintiff side. And we wrote a book back in 2010, and then we did a retread in 2016. And then as the Unified Patent Court came online, we've done now our third edition of this to track the structure of it and the strategic value of it. And there is a lot of fundamental strategic value in the way the UPC is structured. And this very quickly has become the forum now for patent litigation. And so now I want to introduce Konstantin. Konstantin, you want to say a bit about yourself and your practice?
Yeah, thank you very much for having invited me. Thank you, Stephen, for the introduction. My name is Konstantin Schallmoser. I'm a German-educated patent litigator. I used to work in Munich, and I've moved now 10 years ago to Paris, France. I'm doing patent litigation and revocation actions in almost all fields of industry and business. Yeah, that's it from my side.
Very good. Well, let's jump right into what's going on, because it has started. So we'll talk first about the structure of the UPC, and then we'll talk about what's been happening in practice since the launch of the UPC. So, Konstantin, when did the court go into effect, and what kind of IP rights did it have jurisdiction over?
Yeah, the UPC agreement was originally signed in 2013, and then it had to be ratified. This is a proceeding that takes a long time in Europe because every state, every country has to ratify, and ultimately it went into force on June 1st, 2023, which means like 30 months from now on. And the Unified Patent Court is a court that is does not only have jurisdiction for an invention that has been filed from that date on, but has jurisdiction for all existing and future European patents. This is one of the key points that you have to know. That means that all European patents that are still in force and that have a date of application after June 1st, 2003, they are into this system when they are still alive. So all existing and future European patents that are granted, will be granted, or have been granted by the European Patent Office. You see in orange that we've put in there which not have been opted out. We will have a short point on this opt-out because actually it is possible to register that a patent shall not fall, that is existing shall not fall under this new system. It was kind of a reinsurance for stakeholders that they are not obliged to get into the new system from the very outset. But unless you don't do this, unless you do this, you will be in the system. And then the UPC has jurisdiction also for the unitary patents. A unitary patent is a kind of an abbreviation for European patents with unitary effect. It means that this is only European patents that have been granted after June 1st, 2023. And then within 1 month, you can apply for the so-called unitary effect, which means that this European patent is automatically validated in the 17 or now 18 countries of the European Union in which the Unified Patent Court is in force. The system is now fully established, and we see case law emerging quickly. We've seen a lot of first instance decisions. We have not seen a full bunch of Court of Appeal decisions. They come up one after the other, with some questions being resolved. Others are still not finally resolved.
Very good. Thank you. So here we've got a map of Europe, and what does this map represent? And we'll compare that to now what's the jurisdiction of the UPC. So what's in red here?
Well, we will have several maps on the next slides, and it's really important to distinguish these countries because we start with the map with the most countries involved. We have like here 39 countries, and they all cover the European Patent Convention. The European Patent Convention established the European Patent Office in the late 70s, 1970s. And basically, it's one organization that grants patents. And whenever you want to have a European patent, you have to do this by asking for it at the European Patent Office. It covers the whole European Union, but it also covers very important countries that are not part or not part anymore of the European Union, such as Switzerland, Turkey, Norway, and of course the United Kingdom. And as you can see, with 570 million inhabitants, it covers a huge market, and they are all covered by this organization, the European Patent Office. And what then happens when the EPO grants a patent, it falls to a bundle of national patents. So when the patent is granted and you validate it in one of these countries, it will be treated like a national patent. And of course, in all these countries, we have still national patent offices. They continue to grant national patents. This is a layer which is separate and different from the EPO. And the national courts, they continue to have jurisdiction over all cases based on European patents or national patents, at least during a transitional period until 2030.
And I want to underscore from a litigation standpoint, what this meant was that if you got a patent through the EPO, you could enforce across all these red countries, basically all of Europe. but you would have to do it on a country by country basis. And that was very costly and very slow, and you have a lot of inconsistent decisions. So that was a drawback of the old system. So now what we've got is the Unified Patent Court, and the map looks quite different. It is, we got 3 different colors, or 4 different colors even, and it's quite different. So Konstantin, what's going on here with the UPC?
Well, there was a lot of discussions and political discussions and also judgments and opinions going on between the end of the early 2000 years and now. And it turned out that the Court of Justice of the European Union said that it will not be possible for countries outside the European Union to take part of this adventure, which is called the Unified Patent Court Agreement. So all countries that are not members of the European Union were kicked out in 2011 from this project. So this removes Switzerland and later removed the United Kingdom, but also Iceland, Norway, Turkey, to name some. And then there was some political objection in other European countries, especially in Poland and in Spain. They wanted to stick with their own national system. So they did not ratify this agreement. And then we have some other countries like Greece or Hungary or the Czech Republic, which eventually will take part in the Unified Patent Court, but they don't do it for now. There has been some evolution in the last years. Romania joined and as 18th country, and we are still hoping that Ireland will join the system in 2027. So if you look at this map, the countries in dark blue, which represent 315 million people, they are in the system. So basically the whole Central Europe, Germany, France, Italy, which is by far the most important European industries besides the United Kingdom, the Nordic countries and the Benelux countries and some in the east and some in the west. So we have these 18 countries and they take part of the Unified Patent Court, but it's without UK, Spain, Turkey, Poland, Switzerland, Norway, and other countries. And in these countries, you can apply for the unitary patent. As a reminder, the unitary patent is only open for European patents that have been granted since June 1st, 2023. And in these 28 months, we have seen 70,000 requests for unitary patents. I think there are 10 have been denied, but the rest has been granted. And we see now 25% of all newly granted EPs are unitary patents, which the main benefit of the unitary patent is that you have one single office, which is the European Patent Office, to do your renewals, and you have one single annual renewal fee, which makes it a lot easier for you to have patents validated in Europe, and you get basically the most important countries in Europe.
Very good. Thank you, Konstantin. You want to tell me a little more about the deadline to request the unitary status? What do you need to do in order to get this unitary?
Yeah, when we're talking about the unitary patent, this is, I mean, it is a very important crossroads in the faith of your European patent. And we have seen patent holders that have missed already this deadline because it's only 1 month after the patent has been granted, and 1 month is really very short. But the reason for this is that or third parties involved have to have legal certainty. Does this invention fall into the new system with being a unitary patent or not? So
Once
this is
a grant of a patent, you got then 1 month to elect to have a unitary effect. Is that right?
Yeah. But you can do it, of course, before you get a notification that your patent will be granted, 3 or 4 months before the patent is actually granted. So you have 4 to 5 months to discuss this with your client or the other stakeholders.
So let's talk about the jurisdiction of the court. So the UPC, the Unified Patent Court, what kind of IP rights does it have jurisdiction over?
Well, this is one of the most important slides we will have for you today, because we really have to know what is the jurisdiction about. As I told you, the UPC has jurisdiction for unitary patents, but it also has jurisdiction for European patents, and not only new ones but also old ones. And this is something we have still last year. I talked with patent attorneys and attorneys from other countries, and they said, yeah, we basically we don't care about the UPC right now because we didn't file any unitary patents, so we are not concerned. This is one of the key mistakes you could do with the system. You should be reminded that all European patents after having an application date after June 1st, 2003, 20 years ago, could fall under this system. So it's new unitary patents, new European patents, but also old ones, of course, patent applications, but we have seen no case involving with respect to an application, and also the SPCs, they can be litigated through the UPC. On the other hand, we don't have jurisdiction for EPC states which are not participating in the UPC agreement, which is, as I mentioned already, United Kingdom, Switzerland, Turkey, Norway, Iceland, but also the countries that could be at a later point in time part of the UPC, but that aren't. We have seen some cases where parties try to get an injunction for Ireland or for other countries, and the court said no, as long as they are not contracting member states, you will not get this. So for these countries, there will be no change with respect to the old situation.
Okay. Now, what kind of IP rights are not to be enforced in the UPC?
Well, it's as always with Europe, you have always different layers. So the establishment of the Unified Patent Court does not mean that we don't have any national patents anymore. The national patent system remains unaffected. It remains unchanged. And you still can apply after you have your PCT application. You can still apply for a French national patent, for a German national patent, and you can even do both now. You can have a European patent and you can have a national French patent and a national German patent. For these national patents, the UPC will never have jurisdiction. And in some countries, especially in Germany, we have utility models. They are a very cheap possibility to get a first protection because they costs like 300, 400 euros plus cost for translation, which usually is a machine translation. So this is a very cheap way of having protection from the very outset. And these are, of course, still litigated under the national systems.
Very good. All right. So that's a very important facet of the UPC is the different divisions. You've got local and regional divisions on one hand, and then you get a central division on the other hand. And it's important to know this kind of two-division structure. So can you tell us about that?
Yeah, one sentence before this is that we have a two-instance court system. We have what we see here is different divisions in the first instance, and then we have one court of appeal. There's no third instance, so we have like a two-instance system, and then it's final. The divisions in the first instance, they are spread all over Europe. And basically we have on the one hand, local or regional divisions. A local and a regional division is basically the same. The only difference is that a regional division covers more than one country. We have one, which is called the Nordic Baltic division, covering the Baltic states, Estland, Lithuania, and Latvia, and Sweden. And then we have a lot of local divisions, especially the four local divisions in Germany. They are based in Munich, Hamburg, Düsseldorf, and Mannheim. We have a local division, important one in Paris, and we have one in Milan. And they have jurisdiction for usual patent infringement action. So when you start your infringement action, you usually will go to a local division. Same for a preliminary injunction. And once there is an infringement case pending, the counterclaim for revocation must be brought or should be brought to this very local division. They have also competence. Have also jurisdiction for the evidence preservation, what we call in France the saisie contrefaçon. That falls in that jurisdiction too. The central division, its main competence is actions for revocation, standalone revocation actions. They have to be brought to the central division in Paris, or they have some subsections also in Munich and in Milan, but basically it's in Paris. But there could be patent infringement cases with the central division also, but this is something we have not seen so far in the last 2 years. And
Okay, so
the
by contrast
central
to the
division,
US, it's if we go to enforce a patent, like in the US, you go to a district court to enforce your patent, that's analogous to the local divisions, the regional divisions,
yeah, yes.
all throughout Europe. Whereas here in the US, we get the PTAB, where you go to challenge the validity of a patent, and that's analogous to the central division in some respect. Is that right, Konstantin?
That is right. But what we have seen the last 2 years is that the very essence of this court, it plays within the local divisions. So
Right.
there's a big emphasis on what's going on at the local divisions, and the central division does play a minor role so far.
Good. So now let's talk about the case calendar, and this is a big distinction with the U.S. So U.S. case, you file a complaint, you may be in court for a number of months before a PTAB challenge is filed, and then you may be on hold for 18 months while the PTAB plays out. And then if you win the PTAB, the court may resume, and you may have a year and a half or 2 years more of litigation. So maybe really a 4-year timeline in the US before you get to a trial. By contrast, how is that working in the UPC?
Well, this is a major difference to what you just described for the US system, but it is also in the same way a major difference to what we have seen previously before the UPC came into force. We have a system which is based on the idea that you have more or less than 1 year per instance, which gives us 2.5 years until a final and binding decision. And they stick to it. It was one of the most important questions and uncertainties. Will they really stick to the calendar? Because the calendar, as foreseen, the course of the proceedings, as foreseen in the rules of procedure, once the statement of claim is served, then you have 1 month for a preliminary objection, which basically only concerns jurisdiction. And then you have 3 months for the defense of counterclaim. There you have to bring for the defense of the statement of defense against the infringement action. And you have to include, if you want to bring attacks against the validity at this time, the counterclaim for revocation. Then it goes on with the reply. And then basically everybody after 5 writs has said everything. And then we enter into the interim procedure phase, and with a first oral hearing, which is basically organized by video conference. And then we will have the oral hearing, which is after 12 months. And they doing it. They are constantly and repeatedly refusing our requests for extension of time period because we have holidays, we are ill, we are sick, we have children, we have other hearings, everything is rejected. Basically, they say whenever you are in a case for the UPC, you have to stick to this calendar. So we have these decisions after 15 months, 12 to 15 months.
Well, it's a major distinction between the US and Europe. And also from the strategy standpoint, in the US, there's many off-ramps for defendants. You may have a motion to dismiss, you may have a Markman hearing that gives you an out, you may have summary judgment that may give a defendant an out. But is there anything like that in Europe?
No, basically, the idea was, and I followed the discussions like 15 years ago, and the main concern of industry and people, stakeholders in the patent system is always it takes so long until we have a decision or until we have our damages. We have spent a lot of money and we have had years where we are in uncertainty. We didn't know, could we launch this product? Could we get another product of a competitor out of the market? And so the basic idea is really we want to have this being a fast system, the fastest system worldwide, if I can see it.
Right. And in the US, often our district court proceedings will be put on hold pending a separate challenge in the PTAB, whereas here, the counterclaim is being adjudicated in the same proceeding, and so it's all happening at once. Is that
Yeah,
right?
and I mean, we have seen some situations where there were European Patent Office opposition proceedings still pending, and the opposition proceeding, there was an oral hearing scheduled like 4 months later, and the defendant in the UPC case asked for a stay of the proceedings pending the outcome of the opposition, pending with the EPO, and the court, the Unified Patent Court, said no. 4 months, we will not take so much time to wait for the outcome of the opposition procedure, which clearly shows their attitude towards this calendar. They want to have it decided within 1 year.
In terms of the advantages of the UPC, and this is what I'm seeing as a US litigator, is that it provides pretty much one-stop shopping. Now, not every country in Europe, you can't get enforcement in Spain and Poland, but and not the UK, which is quite important, and Switzerland too. But for the core countries in Europe, so the Germany, France, Benelux, Italy, you get all that enforcement in one spot. And it's faster. It's a lot faster. So we're really talking about a year, maybe 15 months to a trial resolution, and about a year for an appeal, as opposed to the US, maybe 4 years for trial, plus another year for appeal. And it's quite predictable, is what I'm hearing. And so, and discovery doesn't bother. There's really quite limited discovery. And so for a plaintiff side, you need to have your case together. And if you can't prove your case, you really don't have a lot of business being in the UPC. But if you can prove your case in the outset, it provides a lot of certainty and a very streamlined procedure. Is that what you're saying there, Konstantin?
Yeah, basically you said everything I wanted to say on this slide. It is really the key advantages that you have, basically the possibility to have an injunction or whatever outcome you seeking for the most important countries of Europe. You need only one court case. There are some first decisions from the Court of Appeal saying also that we will apply the law of the Unified Patent Court Agreement uniformly, also for cases that have started already before 2023. They say that if you have an infringement and proof of infringement in one of the UPC countries, this is sufficient to get an injunction for all the UPC countries where the patent is in force, which is a major difference because you don't have to collect your infringing products in 10 different countries. You just buy it or get your proofs done in one country, and then you go through it. There's one huge important point that we have to add is that all these advantages, they are subject to a very sincere preparation of your case. You need to have basically everything in the statement of claim because the court and the judges, they are very reluctant to allow new evidence once this first step has been done.
And to add one more very key advantage to the UPC is a willingness to grant injunctive relief, which in the United States, it's hard to win an injunction.
Well, there's no discussion. We just had one or have one case where the defendant wanted to discuss this, and the court said no. Our basic rule is you get an injunction. If we think that the patent is valid and that it is infringed, you get the injunction. And there might be theoretically cases where injunction would not be the best outcome because there are third parties' interests or whatever, but they always denied it. They always denied it. And also, which is important, is that when the defendant brings it up, it's up to him to bring all these arguments and to convince the court. And as until now, the courts have not been convinced that there's no need for an injunction.
And so from my perspective in the US, what companies are saying, especially when they want to enforce the patents, is Europe is the place you want to go. It's faster, the expenses are way lower, and you can get injunctive relief. And so what I'm very much seeing a shift in where companies want to enforce their IP. and it's going to Europe.
That is true, and we have one indication that clearly shows that this is true, and we have seen a huge number of cases that have been settled after a first instance decision. And the reason for this is that once you have a court saying the patent is infringed and it is valid, and you may enforce it with maybe a bond to be paid or not, because a lot of decisions did not require the plaintiff to make a bond. And then basically within some weeks, you have a settlement because the market is down, and that makes parties move.
So some of from a prosecution standpoint, trying to get patents, you've now got layers of different kinds of IP rights. And I want to make sure that's clear to the audience that there's different kinds of patents you can get and different strategies for assembling that portfolio. So what are the different layers, Konstantin, of patent rights you can get?
Yeah, we touched on this at the beginning already. We have the unitary patent, which is the newest, latest on what you can do, which is the European patent granted after 1st of June 2023. And then you have you request the unitary effect, and you have protection in 18 countries. You have only one annual renewal fee. You have only one office to deal with. So it reduces significantly administration work and costs. And you can litigate this in all of the 18 countries. Then we have the traditional, I'm sorry, European patents that can be opted out, which means that for the time being, they are not in the system. The opt-out could be withdrawn once you see that you have now an interest in going to the UPC. And as I mentioned it, we have national patents still. The national patent system has not been affected, and we have even the possibility to have identical patents for Germany and France in parallel to the European patent or in parallel to the unitary patent. So you can mix and match, and it depends on where are your market. It depends on how much budget do you have for protecting your inventions, but you should consider carefully all of these possibilities.
There's been a lot of talk, especially when the UPC came online in 2023, about whether to opt out, meaning whether to file a form that says this patent shall not be subject to the UPC. And there was a lot of interest in whether to opt out. So can you explain kind of the pros and cons here of opting in or opting out, pardon me?
Yeah, my personal view has not changed over the last years. For me, it is a no discussion because it does not make sense to opt out. But this is only my personal view as an introductory remark on this slide. The opt out brings you to a situation that the UPC has no jurisdiction for actions relating to the European patent, and it can be withdrawn later on if no action was pending in relation to that EP on a national level. So the main advantage, or what people thought would be the main advantage of opting out, was to avoid a standalone revocation at the UPC that would invalidate rights across all participating countries. And of course, we have seen some important opt-outs for pharma patents that are litigated all over Europe, and that are where the patentee was really looking for to avoid a situation where the patent is revoked within one shot. But on the other hand, we have seen only like 70 standalone revocation actions out of 600,000 opt-outs that have been declared. So it was a massive administrative task for not a real issue. And the disadvantage of the opt-outs that you have then to enforce country by country with risk of divergent rulings. Of course, if you have a very poor, weak patent, you might think about getting at least one egg in the basket. But basically, this is the main disadvantage of the opt-out.
Yeah, from my perspective, we had a lot of U.S. clients who were very concerned that their IP could be, with one well-thrown challenge at the Central Division, the PTAB of the UPC, that they would lose all the rights with one single challenge. Whereas if you have national rights, it's a lot harder to knock those rights out. And so there was a general inclination when this came online to opt out to avoid that vulnerability of a single challenge at the central division wiping out the entire portfolio.
Definitely. This reason was a good reasoning for patents that are already litigated or that are about to being litigated. For patents where no litigation is in sight, where no competitor is really making use of your invention, it was not necessary because you don't just initiate revocation actions, which triggers a lot of costs, and you need the people and you need the state-of-the-art research. And so basically, for patents that are already litigated, it made sense. For patents that are just there and you don't know what will happen, it was not a good idea.
So let's talk about money in terms of cost of going through the UPC. So we got 3 slides here, kind of first about court fees. So can you talk about the court fees? How does it compare to the old school German litigations?
Yeah, we have a system of court fees where we have a fixed fee, which is for infringement actions, 11,000 euros, and then you have a um, value-based fee, and they are counted together. And then you see the value in dispute and in every line, and then you can compare it with the German system we used to have. We have seen just one remark on this: values in dispute. They are usually in the range between 500,000 and 10 million euros. Most cases are between 1 and 5 million euros. We have some big pharma cases where one case where the value in dispute is more than 100 million euros. But basically, in most cases, we are in between 1 million and 5 million. And the court fee is then between 15 and 40,000 euros. If you compare this to the German system, not only one instance is cheaper with the UPC, but you have the same cost in appeal. So if you double this second column, you have your maximum cost risk with respect to the court fees. Whereas in Germany, you would like to have to multiply by 4 because you have 3 instances, and every instance it's getting more expensive. So it is a lot cheaper with the UPC. And this is really in contrast to what people think about the system. They said, it will be very expensive. At least for the court fees, we don't see this.
And comparing the revocation actions, so how does it compare, the UPC versus Germany?
Yeah, to start with the second takeaway, the court fees for revocation actions in the UPC, they are aggressively lower than in Germany. We have seen in Germany that patents, also weak patents with a huge economical impact, they are not challenged by the defendant simply because the court fees, they are too expensive under the German system. So in order to not make the same mistake, the founders of the UPC, they said everybody should have the possibility to attack a patent and to argue invalidity of that patent. So they made a cap at 20,000 euros for the court fees for the revocation action. So it's aggressively lower than the court fees that have to be paid in Germany.
Okay. And briefly, this is a concern is the loser pays scenario. So in America, it's basically the American system, which is each side pays their own fees, whereas in Europe, it's a loser pays. And so what's the risk here on the plaintiff side if you lose? How does that happen, and then how does it compare to the older German system?
Yeah, maybe we'll start with the traditional German system. In the German system, we have statutory fees, and the cost reimbursement is foreseeable to that end that if you start with the right value in dispute, and usually you do, then you know in case you lose, this is the amount you have to pay to the patent attorney and the attorney at law that has been representing your opponent in this case. Whereas in the UPC system, there's no such statutory fee, but you have maximum a list of a maximum amount that can be reimbursed. and it's getting up to several €100,000. We have not so much case law so that I can give you a good overview on this. What we have seen is that in almost all cases that are not clear, where the outcome is not clear from the outset, parties agree on a maximum cost reimbursement that is lower than what is in this list, simply to minimize the risk. And that's what's playing out now. So for the time being, we don't see very big numbers with respect to cost reimbursement, but there's a small caveat. We don't have jurisprudence on this in all questions.
Very good. So we're going to pivot now and see how it's been kind of playing out in practice. So we got the basic structure here, and I want to see what's happened over the last 2 years. So first, opt-outs. I did teach constantly the word stampede, and stampede to the exits. When people were being confronted with the launch of the UPC, a lot of people opted out. And so how has this played out, Konstantin?
Well, this is one of the lines that did not change in the different presentations we made the last 2 years. It was 34% of European patents that have been opted out of the Unified Patent Court system. This number was true in 2023, and it is still true end of 2025. We have around about a third of European patents that have been opted out. We had some clarifications of the Court of Appeal saying that if you have opted out and there was already national litigation going on, you could still opt back in, withdraw your opt-outs. This happened in some major cases. So we have seen this stampede, as you teach me the word, but the number remains rather constant. And as I told you, once opted out, it can be opted back in, and this is what happens when you have litigation inside.
Let's talk about evidence procedures. This, for me, is a fascinating aspect of European litigation, and it is not available in the U.S. And in the U.S., we've got very broad discovery once you have a case going. Once you get in the case, you have very broad discovery for, the emails and the lab notebooks and the procedures. All that is fair game. Whereas in Europe, we really don't have that. But in Europe, what you do have is this front end procedure, this evidentiary seizure. And it was part of French law and some other countries around France.
Yes.
But now it's being part of the UPC. And so these evidentiary seizures are a very interesting procedural aspect of UPC litigations. Can you tell us about how it's playing out in practice?
Yeah, this is something stakeholders make use of. We have seen something like 100 cases for preserving of evidence. I was involved in one. This is the Metals versus Danieli case, and maybe I could best explain in this case. It's a pending case, but the saisie contrefaçon part is finalized. So we had the infringer, or the alleged infringer. We knew that there was that they have sold a machine to a US client, but we didn't know if there was a European entity involved in this project. So we went to the court and we said, look, we have some pictures of the machine. We think that it is an infringement. We explained them why we think that it's an infringement. And we said, but we don't know if there was any European entity involved because we cannot see it from the pictures that were taken somewhere out in Kentucky, I think. And then the court said, okay, so let's go to their place in north of Italy and find out if they, in fact, were part of this project or not. And that's what we did. We got the information. It was bound to confidentiality for some time. Then we have found an agreement with the representatives of the defendant, and the case is now pending on the merits. But this was the starting point to get into it, and we could not have started these proceedings without this seizure proceedings, because we had no clue about who was actually involved in that project.
So it gives you a very early attempt to get some key evidence. But then once this is done, there's no discovery during the course of the litigation, right, Konstantin?
There's no discovery. You have some other means, like you can ask for the production of other evidence, but usually you start with this and then you're gone. And talking about this case where we were involved, we actually went to start preserving of evidence proceedings to two entities, and we quickly found out that the second one was not into the project. So we found an agreement with the counsel of opponent and put this second entity out of the litigation, which was in fact good for everybody because costs remained low and no one was involved, where there was no question anymore that they have infringed the patent.
And in distinction to U.S. litigation, this really keeps costs down. You get a very quick seizure action to grab some key documents. It's got to be focused, but you can do it. And then you're off and running with the litigation, and it really cuts down on discovery costs. So let's move on. Let's talk about preliminary injunctions. Another big distinction between Europe and the U.S. In the U.S., it's rare, very rare to be able to get a preliminary injunction. How's it playing out in Europe?
Well, we have a certain willingness of granting a preliminary injunction. Maybe just to give you the contrast to what happened or what used to happen in Germany. In Germany, we have a split system, so the court that is hearing the validity of the patent is not the same that is hearing the infringement case. So whenever you start a preliminary injunction proceedings before a German civil court, the German civil court said, okay, if we are not really convinced that the patent is valid, we will not grant this injunction. By contrast, this changed with the UPC system, where we have panels of judges where always a technical judge is involved. In most cases, this is someone who still is or who used to be a patent attorney. So he is part of the panel of judges, and they have this technical knowledge within the panel, and then they have a look on both infringement and validity. And if they are convinced that it is more likely that the patent is infringed and valid than it is not, then they grant the preliminary injunction. In this case, 10 times genomic versus nanostring, there wasn't even a necessity for a bond to be paid. No security was paid, had to be paid by the plaintiff, because it was the Harvard University also, and they said they have enough funds in case that the preliminary injunction is revoked at a later time, to reimburse the damage that has been caused. This PI, however, has been lifted. It was a rather quick case. So the case started really on June 1st, 2023. It started the very first day, and we had the injunction being granted end of September, so roughly 4 months later. And then the case went up to the Court of Appeal. The Court of Appeal had the hearing at end of December 2023, and they rendered their decision in February 2024. And they did not say anything about infringement because from their preliminary assessment, they said that most probably the patent will be revoked, and therefore they lifted the preliminary injunction that had been granted.
Okay.
But in general, it is we see it all the time, and they grant it.
Right. So here's a flip side of that, where this Boehringer case from Lisbon, Portugal, where at the local division level, there was no PI granted, no preliminary injunction granted, but then at the Court of Appeals, they set it aside and actually granted the PI. Is that what happened? So give us a little context.
Yeah, actually, I put those two slides in there to also emphasize that we have a lot of first instance decisions, but we have not so far real certainty as to how the Court of Appeal will develop its own case law. And of course, then the Court of Appeal case law has to be applied also by the first instance decision. So the local division Lisbon, it was actually their only case until now. They did not grant the preliminary injunction because they said there's no risk of imminent infringement, whereas the generic company already had fulfilled all administrative tasks that are necessary to bring the product on the market. And the Court of Appeal did not accept this. They said once you have done all the administrative proceedings that need to be done to bring a drug on the market, which in this case required a prior evaluation procedure with setting prices. If it's only a matter of starting the action, of putting the button, then there is a risk of imminent infringement. But what is the interesting point is that they, in a second step, then said, okay, we have this risk of imminent infringement in Portugal because in Portugal we have done all this. And if you have this in one country, we will grant DPI for all the UPC countries where this patent is in force, because that is the basic rule of Article 34. You just don't do it by country on a country by country basis, but you grant the injunction for all the countries.
So briefly, before the UPC, Germany was the dominant forum for patent litigation in Europe. And now you got the UPC with all these different countries. Is it still the case that Germany is dominating?
Yes, it is still the case. We will have the figures on the next slide. And from now on, which is, from my point of view, not a good thing, but it is as it is. The Unified Patent Court is mainly a German Unified Patent Court because we have, of course, some trust of the stakeholders in the patent system. They have seen so many cases in the last decades that have been dealt with in the German cases. They have seen good judges. They know the names of the judges, and all these judges, they have been they moved to the Unified Patent Court, so we have the same names and we know them. And it was in a way a natural move to choose the same judges that already were known in this field. So they are still choosing Germany, but by way of the UPC.
Let's look at the statistics real quick. Well, to cut the chase, about 80% of the infringement cases are being filed in Germany. Is that right?
Yes. So if you have the text you see over there on the top of the slide, you will remark that the 4 local divisions in Germany, each of them has more cases than the next one. So even Hamburg has more cases than we have in The Hague and that we have in Paris. 80% of all infringement cases are filed in Germany. And in order to cope with the caseload, new judges had to be appointed, and there's a rule that in the German divisions there have to be 2 German judges. In the French division there have to be 2 French judges. So because there was so much of a caseload in the German local divisions, they essentially had to appoint more German educated judges, and part-time judges have been raised to full-time judges. So there is no end of German predominance in sight, despite and I can only mention that I have 2 cases going on with the local division in Paris, and they have a good quality, so might be also worth it to bring cases to this division here. But for the time being, we see a predominance of the German local divisions.
Let's move on from here. Let's talk about the German national patents. You've got these different layers where you can bring case in the UPC, but you can also bring case in the national court, even with national patents. And so how is this layering playing out?
Well, the German system did not it did not change. It did not alter. What changed is that the judges that we have seen before, they are now UPC judges. But there are still a lot of cases going on. If you just take the last bullet point here, we have more than 200 new cases in 2025 only for the National District Court in Munich, which is a high number. So it is still possible to bring cases to the German system. Personally, I would not recommend it because we have talked about the downsides and we see a kind of a brain drain, if you could say it like this, that we have a lot of unexperienced judges that have experience of less than 2 or 3 years in patent litigation. And therefore, I think that on the long run, the case number in Germany will go down and the UPC will take over.
Now, as for NPEs, so non-practicing entities, and sometimes called patent trolls, as a derogatory term, Are these patent owners really taking advantage of the UPC? Is that taking off, or how is it playing out? And what are the restraints on that kind of activity?
It is, from my point of view, too early to have a real tendency because we have seen some big friend cases, some big SEP cases, and they have been decided. And but it's not, as you mentioned the word, it's not a stampede of the NPEs towards the unified patent court. But let me just remind you that why it might turn out to be a good idea to come to the UPC, because you have in Germany the problem that when you have a first instance decision that is good for you and you want to enforce it, you have to pay a bond if you win in first instance in order to cover the risk of the defendant that the patent later on will be revoked. And this bond that could go up to several. We have seen one case where the bond was 3.4 billion euros because it basically was an injunction that would have stopped the production of automotive industry as a whole in Germany. So they said, okay, the patent is infringed, but if you really want to enforce it, you have to pay this bond. And we don't have this requirement anymore, at least not in this way. And of course, if you have a decision which covers infringement and validity, and this after 1 year, then it makes a lot of pressure, especially to the defendant, to settle this case. So this is one of the reasons why I think that we will see more and more cases, especially from NPEs before the UPC.
To wrap it up, the UPC is, despite the name of the Unified Patent Court, is not really unified. It's a Swiss cheese, but without the Swiss. There's many countries that are not in the UPC. And from a perspective of trying to get European enforcement, pan-European enforcement, how does this limitation of the structure play out? And then what are the recent developments in the case law?
Well, we have seen that the UK will still play an important role when it comes to the importance of their judgments they give. They have a very high educative way of drafting judgments. They go really deep down. We have, just to give you a comparison, we had one case going on that has been litigated on one single day before the District Court Munich, and the London colleagues from the High Court, they have been litigating this for 16 whole days. So the UK, by its intellectual power, will still play an important role. Other countries will have it more difficult because the big part of the European market plays, of course, in the UPC now. But of course, there are industries where you have products that are sold on a country by country basis. And of course, then you have to go to the other countries like Spain or Switzerland or Eastern Europe to get your injunction wherever you need it.
Now, lastly, and we'll talk about this much more at the conference on November 20th. We'll have a deep dive there. But this is a very important development in the case law. What can you tell us about this BSH Hahn-Geräte case?
Yeah, it is a very important decision from the Court of Justice of the European Union. And basically, it says that if you have a defendant that is domiciled in one of the EU countries, then you can sue this defendant for infringement for patent infringement with respect to all territories of this European patent. So you have a German-based defendant, you sue him for the infringement of the French part of European patent, or for the Italian part, for the German part, for all these countries. This was not possible until beginning of 2025, and it applies also to the UK, to Spain, and to Switzerland. And this is very new. We've seen a lot of cases both before national courts and also before the UPC, because it turns out to be applicable also to the UPC. We will see a lot of discussion, especially on November 20th, on this very important judgment.
Right. So even though the jurisdiction of the UPC is somewhat limited, we have now this case law that gives more of a long-arm jurisdiction to offer more pan-European enforcement. So I think with that, let's save more comments for the panel on the conference on November 20th. And thank you very much for listening.
Thank you very much for having me.
Yeah, and thank you both. And I look forward to seeing you shortly in DC. It'd be great to go into this in more depth.